Hello and welcome to this session in which we will discuss the rights of secured creditors. Secured creditors are the people or the institution that gave out the loan or sold something on credit to the debtor, but they wanted to make sure that they are secured. Secured in a sense, in case the person does not pay, they have a collateral they can take back, sell, and pay back the loan. So what they do is they create an attachment and they perfect this attachment, and this is what we talked about in the prior session. In this session, we would look at the rights. The right to do what? To take possession, to take back the asset and sell that asset, sell the collateral upon the default. Upon the default means when the other individuals don't pay their money. And this is a key provision in secured lending agreement. This rights allow the lender to do what? To take control of the asset pledged, whatever that asset is. Could be a car, could be a TV, could be a piece of furniture. If the borrowers fail to meet the terms of the loan agreement, it means the borrower defaulted. And this is what we will discuss in this session. In the prior session, we looked at attachment and perfection. If you don't know what these are, please make sure to go back and review them. Before we proceed any further, I have a public announcement about my company, FarhatLectures.com. Farhat Accounting Lectures is a supplemental educational tool that's going to help you with your CPA exam preparation as well as your accounting courses. My CPA material is aligned with your CPA review course such as Becker, Roger, Wiley, Gleam, Miles. My accounting courses are aligned with your accounting courses, broken down by chapter and topics. My resources consist of lectures, multiple choice questions, true-false questions, as well as exercises. Go ahead, start your free trial today. Two methods to take possession. So how can they take back this asset? Well, actually, self-help. Self-help means what? It means they can go themselves and take the asset out because they have an agreement with the borrower. Usually that does not happen. Usually the business person, they hire someone, a repo team. And this concept is so popular in the US that there are TV shows and movies about this, the repo man. This method allows the secured party to take possession of the collateral without needing to go through the court. And that's why you created the secured lending in the first place. You don't want to go through the court because that takes time and it costs money. As long as you don't disturb the peace, you don't breach the peace. So in case that individual that you're taking their asset, they pulled a gun or something like that, that's a breach of the peace. You have to take an alternative option at that point. So a breach of the peace typically means causing a disturbance or using force. For example, if the borrower defaults on a car loan, the lender can take back the car without a court order as long as they do not disturb the peace, such as by breaking into a locked garage. Usually what they do, those repo teams, they come in at night, they will take it, they will follow you. For example, if you watch these shows, they wait until you go to a shopping center where you're shopping inside, you come outside, your car is gone. So they make it as smoothly as possible without breaching the peace. Well, if this does not work, what can you do? You can go to court and ask for replevin action. This is a legal process where the secured party asks for a court order to transfer the property to them. Here you're involving law enforcement. This method is used when self-help is not possible or would likely lead to a breach of peace. So let's assume that car is constantly locked in a garage. You cannot break into that garage. For example, if the borrower who defaulted on a loan is keeping the collateral like a piece of machinery in a locked facility, you may need to get a court order to take it back. Once you take it or lease it, you can sell it or lease it. The secured party can choose to either sell or lease the collateral in its current condition or after making some reasonable preparation or processing. Method of sale, how do you sell it? You can sell it either publicly like an auction or you can sell it privately. The sale must be conducted in a commercially reasonable manner. Simply put, it's a sale where the methods, manner, and time are sensible and appropriate to all parties, considering the type of the collateral. Do you have to give a notice? Yes, you have to give a notice to the person that defaulted and other interested parties who must be informed about the sale in advance. Now, I'll tell you, when I used to be a loan officer, this was part of our job, is to sometime when the customer don't pay, we will repo the car. Then we will put it for sale. We would have to inform that individual When we say I, it doesn't mean my company. I used to work with a company called City Financial. We would have to inform the person that there's going to be a public auction. If you're interested, they can bid on the car. Now, what happens if there are multiple liens on that car? Let's talk about this. The sale eliminates all subordinate interests in the collateral. This includes interests of other parties who might have claim on the collateral, like secondary lenders or lien holders and other debtors remaining in the collateral. So simply put, anyone with subordinate interests, once that asset is sold, their interest, their secured interest in that collateral is wiped out. Let's assume it's a car. There are two loans on that car, a primary loan and a secondary loan. So if the person with the primary loan repo the car and sells it, the interest of the secondary loan is wiped out. However, if there's any superior interest, go back to that car, and we're going to work an example shortly. There's a primary loan and a secondary loan, a first loan and a second loan. If the individual with the first loan repossesses the car and they have superior interests, they can sell it and the subordinate is gone. However, if there are someone who's superior to the first loan, means what? Could be what? Could be the government. Then the person that purchased this car, they will have to deal with the government. A buyers who purchased the collateral in good faith at the sale gets free of any subordinate interest, including the first interest, because the first interest sold it, but they would still be subordinate to any superior claims. For example, the government. We'll look at an example shortly. Right to redemption. The debtor, the person that the car was repossessed from, they have the right to reclaim it. How? Pay it off. Pay off the debt and any associated costs before the sale. So if they reach out to you, said, look, I have the money, I would like to pay off that loan. You could allow them, but if there's any cost associated with that repossession, they have to pay it. However, this right ends once the sale occurs. Once the sale happened, they cannot go back and say, we want to buy it again. Too late. Let's look at an example. Emily's buy a car using a loan from Bank A, which becomes the primary lender. Think about it as a, in quote, first mortgage. To secure the loan, the car is used as a collateral. Later, Emily takes a second loan from Bank B and use the same car as a collateral, making Bank B as a secondary lender. As time passes, Emily is unable to keep up with her loan payments. Obviously, she took two loans against the same car. She must be spending a lot of money. Bank A decides to repossess and sell the car to recover any outstanding loan amount. Now, here's how the sale affects the various interests. Bank A sells the car at an auction. Guess what's going to happen? The sale of the car eliminates any subordinate interest, such the claim B. So Bank B is basically gone. Once Bank A sells the car, B has no claim on that car. This means Bank B, no longer has any right in the car after the sale. However, if there are any superior interests or claims on the car, like a government lien for unpaid taxes, the buyer at the auction would have to respect these claims. So Bank A is gone because they sold and they recovered their money. Bank B is gone because they're subordinate. However, if the government has a lien against who? Against Emily, the person that buy the car, now they have the lien against them by the government. These superior claims are not eliminated by the sale. So you have to be very careful when you buy cars in an auction or any auction. The buyer who purchases the car at the auction gets it free from the interest of Emily, of course, and Bank B, and of course they satisfy Bank A, but must deal with any superior claim that existed before the sale. Now we sold the car, we sold the asset. How do we distribute the proceeds? There's a pecking order. 1. The first portion of the sale goes toward covering the cost incurred in the repossession and selling the collateral. Remember, we might have to hire a repo person, or we might have to go to court and incur legal costs. Well, we might have to tow, store it, auction fees. Those are paid first because, this is what made the sale possible. Then, next, the creditors who have a security interest in the collateral are paid. This is done in hierarchical order based on their priority. A creditor with the highest priority gets paid first. Only after that creditor is fully paid do the proceeds go to the creditor who's the next highest priority, and so on. Let's assume we paid all the creditors. Then we have surplus. If there's any money left after paying the repossession, sales expenses, and all secured creditor, the surplus goes to the debtor. And if the sale does not give enough money to cover the sales expense and the entire debt, the lender, the secured party, may take legal action to recover the remaining amount, the deficiency, from the debtor. Let's take a look at an example with numbers. Let's assume Emily takes a loan to buy a car, using the loan as a collateral. If she fails to pay the loan, the lender can take back the car. Let's say the car sells for $10,000. The cost of the repo person and selling the car, the auction, is $1,000. So we started with 10. First, we have to pay those individuals that repo the car, and any selling expenses were down to 9,000. The amount is used off to pay off the loan. The loan is 8,000. What's left is 1,000. After paying 1,000 is left, the surplus is returned to the person who took out the loan. The person that we took the car from, they can get their $1,000 back. Let's assume the car was sold for only 7,000. After paying the repossession and the sale expenses, there would not be enough. Now we're starting at 7,000 minus 1,000. What's left is 6. The loan is 8. We are short 2,000. What can the secured creditor do? They can go after the borrower again. Now they have to file another claim if they want to recover the remaining $2,000. Sometimes it's worth it, sometimes it's not. Let's talk about consumer goods. What are consumer goods? Consumer goods are goods that the individual purchase and they used for personal need. Like they have a TV at the house, they have the furniture at the house, they have the computer at the house. It's used for personal good. When borrowers default on a loan, the lender has different options for dealing with collateral, depending on whether the transaction involving consumer goods or not. So whether this individual that took out the loan is using the asset for as a personal use. Non-consumer goods. So non-consumer goods means a business. After the default, the lender can choose. So if this is, you purchase something and you're using it in your business, you can choose to keep the collateral either in full or in partial satisfaction of the debt. You could say, you know what, I'm going to take back the collateral and I'm done. I'm going to call off the debt. This means, or they don't have to. They could say, you still have to pay me. This means they can offset the value of the collateral against the total amount of the debt, and if necessary, pursue the borrower for any remaining debt deficiency. Consumer transaction. In cases involving consumer transaction, the lender can only keep the collateral in full satisfaction of the debt. So if you want to keep the collateral, so you repossesses that car and you want to keep it. If you want to keep it and it's consumer goods, that's it. So if we go back to Emily's example, if you took back that car from Emily, she was using it for personal use, to go to her work, to go on vacation, to go shopping. It's personal. You repossesses the car. If the person that repoed the car, the secured creditor, kept the car, that's it. They have to call off the loan, even if the car don't cover the whole amount. So even if the loan was 10,000, the car is worth 7, but they want to keep the car, that's it. They have to wipe out the loan. That's what they have to do. This means they cannot pursue the borrower for any remaining debt if the value of the collateral is less than the debt. Now, regardless of the type of the transaction, the lender must notify the borrower and any other secured parties of their intention to keep the collateral in satisfaction of the debt. So you have to let them know. Also, there's something called the 60% rule. Of the transaction involving consumer goods and the borrower already paid 60% of the loan. So here's what's going to happen. The lender must sell the collateral within 90 days after they take it back, unless the borrower says, you know what, you can keep it. Simply put, if the person that purchased this asset, the TV, paid 60% of the TV, then they could not pay the rest. The repo company took it back, the secured creditor has the TV. If the 60% of the loan is paid, they must sell this asset. They must sell it unless the borrower says you can keep it. This rule is designed to protect the consumer by ensuring that the lender does not unjustly benefit from the collateral because it was already paid, basically 60% of it paid. You can't keep it, you have to sell it. This is just a rule. Unless the debtor said, I don't care, you can keep it. Example, consider a person who buys a high-end television set on credit. The television is used as a collateral for this loan. If this person default after paying 70% of the value, the lender must sell this TV within 90 days. They cannot just keep the television in full or partial satisfaction, because remember, if they keep it, that's it, the loan is paid off. They must sell it under those circumstances. The lender must also inform the buyer of their intent to sell the TV. They must give them the notice. If the sale of the TV does not cover the remaining loan, the lender cannot seek the balance from the borrower, because they paid already 60%. You have to sell it, and the assumption is you should be able to recover the 40%. However, if this was a non-consumer transaction, like business buying equipment, non-consumer, the asset is not used for personal use, the lender could keep the equipment and also seek the remaining debt from the borrower. So be careful whether it's a consumer or non-consumer. If it's a consumer, if you want to keep it, you call off the debt. If it's consumer and the consumer already paid 60%, you must sell it within 90 days. Let's take a look at this multiple choice questions from Farhat lectures. In what order are the proceeds of the sale of the collateral is distributed? So once we sell the asset, how do we distribute this money? What is the order? The first thing you have to pay off is to pay the people that repoed the car if you incur any legal expenses. What are these called? These are called sales expenses. So this is the first group. So A, B, and D are eliminated. Then you have to pay the secured creditors. Anything left goes to the debtors. And remember here, depending on what you are repossession, if you are having a consumer good versus non-consumer goods. Remember, a consumer goods, if you keep the consumer good, then you have to call off the debt. The debt is done if you want to keep the consumer good. If it's a consumer goods and the debtor paid 60% of that consumer goods, you must sell it in 90 days. And that's it, call off the debt. If it's a non-consumer good, you can keep it, sell it, you can do whatever you want with it. And if you're short, you can ask the debtor to pay off the difference. Under consumer goods, it's a little bit different. Make sure you're aware of these rules. What should you do now? You want to go to Farhat lectures, look at additional MCQs. That's going to help you prepare for the CPA exam, study for your business law classes. Good luck, study hard, and of course, stay safe.